welcome, welcome. Last day of class. My honor to welcome my mom and my dad, Iris and Jamie. Say hi.
Hello. Hi.
This is Tyler, Audrey, Chelsea, and Lindsay. My class of...
It's like 100 people. It's the final four, man.
Yeah, they all got narrowed out. Now we knock out the winner tonight. Yeah, no, this is rare. Usually on my class I have 90, 80, 70 people. It's just special. I'm grateful for this one. It's fortunate they didn't cancel it on me. I thought they were going to cancel the class at any moment, but you stuck it through. Not everyone made it till the end, but most of you did. Okay, so here's my plan for the last class. I'm going to go through the four cases for today: Romer, Lawrence, Windsor, and Obergefell. And after that, I will go over the final exam from the fall of 2018. And I'll try to answer as many of your questions. It's a weird semester where it goes so quick, and your exam's on Friday. I haven't written your exam yet, and that's very deliberate. I am a terrible liar. And whenever I try to write the exam before the review, people say, well, is topic X on it? I'm like, no. And so I haven't written yet. I don't know what your question is going to be, so I can't even tell you what it is. That way I'm safe. But like one year I was like, you're going to be asked about this, aren't you? I'm like, no. And I had already written the exam, so that's why I don't do the exam review sessions after I write the exam. Okay? Any questions? Anything on your mind? Okay. All right. This last group of cases is a fitting spot to conclude the semester. It really brings together the second half of the course, which is the 14th Amendment. These four cases unite the issues of substantive due process and equal protection in the context of gay rights. All four of these cases were written by Justice Kennedy. All four of these cases are somewhat difficult to follow because Justice Kennedy didn't really care about, shall we say, doctrine or any sort of test. He was guided by a bigger principle. And the principle that animated Justice Kennedy, well, he's still alive, but he's not important anymore, or at least his views aren't important anymore, was the concept of dignity. This is a concept that pops in and out of his various opinions. Dignity, liberty, we saw this in Casey. There are things that were very important to Justice Kennedy. Now, why do I group these four cases together? It's not clear where they fit with the court going forward. We don't know how the court will treat questions of gay rights given the new majority. We don't know if this court will be willing to extend Obergefell to other contexts. We don't know if this court will be willing to perhaps scale back the concept of substantive due process. We don't know if this court will make substantive due process a historical inquiry, that is, only protecting rights that are deeply rooted in history and tradition, and not these sorts of modern and postmodern rights. We also can't look at these cases without understanding the political backdrop in which they arose. In the mid-1990s, gay rights were very different than they are today. The state of Colorado basically enacted this law, amendment statewide, which would deprive any special protections for gays and lesbians. Not even 20-something years later, we have the Masterpiece Cake Shop case, where Colorado was going after a baker who declined to make a cake for a same-sex commitment ceremony. And in the span of just 20 years, the same state that was basically saying gays and lesbians get no special treatment was now saying that we're going to punish a Christian baker who declines to make a cake for a same-sex union. There were no gay marriages at that time in the state, but there was a commitment ceremony of some sort. And so this issue has changed radically in all of our lifetimes in a way few thought possible. When Romer was decided, Congress enacted the Defense of Marriage Act, DOMA, which we'll talk about in Windsor. This was a federal law that was designed to prevent states that legalize gay marriage from having that legalization spill over into other states. In 2003 of Lawrence, where in your backyard, Houston, Harris County, you had a prosecution of 2 men for having sex with each other, allegedly. We'll get there in a minute. And then you have Windsor, right, where the Supreme Court ruled that the Defense of Marriage Act was unconstitutional in part, that those who enacted it were bigoted, that they were motivated by animus toward gays and lesbians, and that was not a valid basis to legislate. And then we fast forward till 2015 with the Obergefell, where the marriage laws in dozens of states were declared unconstitutional almost immediately, where popular referendums, which were enacted with 60-70% majority support to prohibit gay marriage, were now declared unconstitutional. And this change happened in such a fast time. We talk from Bowers v. Hardwick, which we studied in our last class. And barely 3 decades later, we have Obergefell. And this change, this transition is hard to encapsulate. And I think you were all alive for most of it, but I think in due time, it will be difficult to explain to my students how quickly this transition occurred. Even think of segregation. From Plessy to Brown was almost 90 years, 80 years. If my math is right. 70? I can't count. 70-something years, right? It's 1890 to about 1950. I can't count. About 60 years, right? 60 years, 6 decades. And here we're talking basically 3 decades for a radical transformation. All right, any questions with that opening? All right, Lindsay, you want to start us off? And let's do the facts and Romer, please.
Colorado adopted the Second Amendment to their state constitution.
Amendment 2, just so we avoid confusion. It doesn't say Second Amendment. Okay. You're not wrong, but it's easier because the way it works is like you're on the ballot. There's like Amendment 1, Amendment 2, but it's not actually the Second Amendment to the Constitution of the state.
Okay.
Got it? Yeah.
So this didn't allow any action designed to protect people being discriminated based on their sexual orientation.
Well, let's just pause for a minute. What came before Amendment 2? In other words, why did the people of Colorado decide to amend their constitution to put these new laws in? What motivated this change?
There were ordinances issued
Okay.
that protected people from being discriminated.
Okay, let's be very precise, right? What did some of the more liberal cities in Colorado, like Boulder and Aspen and Denver, what some of these cities do? Found Chelsea?
They ban discrimination in housing, employment, education.
Very good. So we all have in every state, in every city, discrimination ordinances that say when you're hiring someone or firing someone, you can't fire them based on X, right? Their race, their gender, maybe their religion. We have some states that say you can't fire someone for being a veteran, right? Maybe they have a disability. When you're renting an apartment, you can't turn someone away, for example, because of their race or gender or disability, etc. Some of the cities in Colorado, like Boulder and Aspen, which are fairly progressive places, amended their ordinances, and they added sexual orientation as protected class. So in other words, now it will be against local law to fire someone because they're gay. Or it would be against local law to deny an apartment to a gay couple, for example. Now, these are local laws, and we don't talk much about local government, but it's an important aspect of constitutional law. In almost every state in the union, perhaps all of them, I'm not sure, local cities enact laws, but the state can then preempt those laws. The same way that federal law preempts state law, state law can preempt local, county, and city law. What Amendment 2 did was basically preempt the local non-discrimination ordinances and said that these local jurisdictions cannot enact these new discrimination laws that protect gays and lesbians. We understand just the frame, right? These were basically preemption. So by virtue of this amendment, all the local laws were effectively repealed. And they were prohibited from enacting new laws that protected these classes. Okay, everyone with me? All right, Audrey. So how did Colorado defend Amendment 2?
They argued kind of three things. They said that it's not discriminatory because it puts gay and lesbians in the same position as everyone else.
Okay.
And then they said, secondly, that the purpose of the amendment is only to deny them of special rights.
Very good.
And then thirdly, from what I got, was that it also protected the freedom of association of landlords or employers who have personal or religious objections to homosexuality.
Okay, very good. Thank you. Let's look at this ordinance from a couple different levels, right? Let's say that you're an employer, and let's say you own a chain of restaurants throughout Colorado. Casa Bonita, remember from South Park? It's a real place too. They have cliff divers and everything. Right, so let's say you own a chain of restaurants in Colorado, and you own some in Denver, some in Boulder, some in Aspen, some in South Park, right? You have restaurants all over the state. You could imagine that business owners might say, I find a problem, right? My employment rules in one city are different from my employment rules in another city. And it might be very expensive to have to comply with, several different standards for employment. And I would prefer a single statewide definition for discrimination. And as a business owner, I don't have to comply with every, local jurisdiction. Okay. Would that be a rational justification for this sort of law, Tyler?
Depends. Colorado seemed to think so.
Okay.
Justice Kennedy not so much.
Now, did the state preempt, for example, a law that says you can't discriminate against veterans?
No.
So there's still this patchwork, right, this quilt, right, where the laws vary. But Amendment 2 targeted a specific type of carve-out, a specific exemption, which was for gays and lesbians. Okay? Now, Tyler, let me ask you a follow-up question, please. What's this business about the freedom of association? Audrey mentioned that a minute ago. What exactly was the state amendment getting at with this freedom of association business? What were they basically saying?
That landlords, employers, etc., could collectively conserve their efforts or collectively choose to associate or not associate with certain causes, but this was not one in particular that the state was going to allow that sort of affiliation.
Okay, so let's break this down. So basically, if a landlord wanted to rent an apartment to white people only, they'd be like, you can't do that. But if a landlord says, I only want to rent to straight people, that would be permissible. Am I reading your comment correct?
That would be permissible, yes.
All right. So then we're basically left with a question that I think will impact and affect everything we do today. Why do some people choose not to associate, work with, live near gays and lesbians? We can all be at least candid and agree it's because of a morality issue, right? That they deem homosexual relations as immoral. And they don't want to be affiliated with such relations, right? We had Bowers from, was it 86, not even a decade earlier. And Bowers said that the state can even criminalize gay relations. Forget denying these guys an apartment. You can throw them in jail for having gay relations. And the basis for that, Justice White said, was moral disapproval. That because people disagree with the morality of what individuals are doing with their lives, that this sort of morality can justify a prohibition on their activity itself. Now, Justice Scalia would argue, wait a minute, if we can throw people in jail for engaging in homosexual activities, then certainly the state can take the far lesser approach and not afford them any sorts of special protections. That's Scalia's position. So there's this tension between Bowers v. Hardwick and Romer against Evans. There's a tension there. Does Justice Kennedy resolve that tension? No, he does not. He simply pretends like it doesn't exist. And this is one of the hallmarks of the Kennedy-Scalia cat and mouse game, as I call it. That for nearly 20 years, Scalia was screaming, saying, "What are you doing, Tony? What are you doing?" And Kennedy just never responded. He did not respond. Now, both of them are off the court. I think it's my first time teaching. I taught fall of 2018, so Kavanaugh was in the court by that point. But this is now for real. It's the first full term after Kennedy is off the court. And it's a different place. But let's still say this a transgression, right? The Colorado Supreme Court basically held that this is an equal protection case, and that classifications on the basis of sexual orientation are suspect. And given a suspect classification, the Amendment 2 will be reviewed with strict scrutiny. That's a more traditional approach. And had the Supreme Court done that, I think I would understand the decision. But let's be very clear here. If classifications on the basis of sexual orientation are suspect, then all laws affecting gays and lesbians are afforded strict scrutiny. At that point, how can you argue that gays and lesbians should not get married, right? If Amendment 2 is reviewed with strict scrutiny, then every marriage law itself will be reviewed with strict scrutiny. Had the Supreme Court in 1996 adopted strict scrutiny, then every single marriage law in the United States would have been unconstitutional. That the military's exclusion case would have been unconstitutional. That would have probably triggered a constitutional amendment to reverse Romer and protect traditional marriage. I think it would have passed by a large majority. Instead, Justice Kennedy took another approach. He reviewed Amendment 2 with what could only be called rational basis scrutiny. But it wasn't the traditional rational basis scrutiny we saw in cases like Williamson v. Lee Optical. Instead, he used a similar type of rational basis review that was employed in Cleburne versus Cleburne Living Center, which we've studied before. Remember, this was the case about the mentally handicapped individuals. And he invoked another case that plays a very important role. We'll see it over and over again. Department of Agriculture versus Moreno. This is a case that my parents would appreciate. It involved hippies. Back in the 70s, Congress passed, I love you. Back in the 70s, Congress passed a law which basically made it impossible for hippies living in communes to get food stamps. The government said, we need this to prevent fraud. And no, the real reason was they didn't like hippies. And Justice Brennan said that, a law motivated by a bare desire to harm a particular group, right, is not rational. And Justice Kennedy will keep coming back to this theme of a bare desire to harm, moral disapproval in his opinions. So the court reviews Amendment 2 with rational basis scrutiny. And he found it flunked. He said that there's no tradition to enact laws of this sort. Right? That this law basically makes it more difficult for one group of citizens to seek aid from the government than other groups of citizens. Right? That if this law was actually concerned about the religious freedom of individuals, the state could have enacted a more narrowly tailored law. Maybe say that if a person has a religious objection, they can't be held liable But this law goes beyond that. It makes it illegal altogether to have these protections. Even if a business has no religious objections to gays and lesbians, they would still be exempted. And they could still discriminate on this basis. And Kennedy says that Amendment 2 is not directed to any legitimate purpose. Amendment 2 simply makes these people unequal to everyone else. A state cannot so deem a class of persons a stranger to its laws. He loves the theme of strangers. In Obergefell, he says strangers in life and strangers in death, right? He's this very idea of being alone. And Kennedy thinks that the only way to have a full existence if you're not alone. Justice Scalia would say, ask the nearest hippie about that one. Actually, it's funny. So Scalia had this one line where, Kennedy said, strangers cannot be, people who are, in order to be fulfilled, you have to have love with someone else. And then, he says, having a relationship makes you more free. That was it. Yes, Kennedy said, having a relationship, being married makes you more free. And Scalia says, nuh-uh, ask the nearest hippie. And then, what's his name? David Crosby came out and said, oh, I disagree. They actually found a hippie somewhere. And he said, no, marriage makes you love, whatever. But Scalia was like, ask the nearest hippie. Sorry. But on this basis, the court reviewed Amendment 2 with rational basis, and they found that the state was enacting laws based on animus or hatred of gays and lesbians. This was a momentous ruling. At the time, almost every state in the Union had enacted laws to bar gay marriage. Even 70, 80% majorities in states approved these laws. But the Supreme Court said no. And I think about 2 months after Romer was decided, Congress enacted DOMA. I think it was a couple months later. I think Romer was, May or June of 96. And DOMA, I think, was September, October of 96. You can check on the month, but they were very close in time. President Clinton signed this right before the election to help himself get reelected. Right? He was, as they say, going towards the middle. But Clinton signed it in 96. So at the same time that the Supreme Court was saying you can't enact laws to harm gays and lesbians, DOMA passed by a wide majority to enact disabilities on only gays and lesbians and no one else. So it was really a decision that was not quite ahead of its time, but almost didn't fit where the country was in large measures. All right, any questions in the majority? Any questions in the Roman majority? Scalia was livid. You can tell when he's pissed. He was really pissed here. He says, what are you doing? Right? We have Bowers. Which says you can throw people in jail for engaging in homosexual activities. How can you say that the state can't take a lesser action and simply deny them special protections? He also faults the majority for not even discussing Bowers, right? You're going to overrule it, right? And at bottom, Scalia says that moral disapproval of homosexual conduct was a legitimate basis in light of Bowers. It's very hard to square Bowers and Romer. We know in hindsight that Bowers will be overruled 7 years later in Lawrence, but at the time, the court sort of just stuck its head in the sand and pretended the problem didn't exist, but it's there. And Scalia will be upset because of Casey, right? Let me get this straight. We can't overrule Roe, but we have to overrule Bowers. And he was livid in these cases. That is your hand up?
No.
Okay. You can ask questions. Okay. Questions on Romer?
Yes, sir.
Good.
Is this the first one that we've seen? It seems different in the sense that this wasn't just a statute congressionally, but this was a full statewide referendum.
Yeah, good point.
Any conversation, did they not even reference any 10th Amendment implications? Are they focused solely on the equal protection aspect?
Yeah, that's a good point, right? Justice Kennedy is very big on purpose. What was the purpose behind this law, right? Why was this law enacted? And he's very willing to say that the people who took this action were acting for improper purposes. They were bigoted. They were acting based on animus. It's one thing when you're talking about elected officials, right? Members of a state house, members of Congress. I think the analysis is very different when you're talking about voters, right? We don't know why voters go to the ballot box and click A or B, right? When we don't ask them. There's not any sort of legislative history, right? There's no committee report about why people vote. People vote what they vote. Mm-hmm. And I think it's very hard to ascribe a single motivation to the votes of an entire state's populace. And I think I have a much harder time with Windsor. I have a much harder time with Romer than I do with Windsor. At least with Windsor, you have reports of government, the legislative history showing here's our intent, here's why we're enacting this, right? You didn't have to guess. But when people vote, most people are lazy, they just vote, don't really pay attention, right? I vote on proposals like, these bonds, I don't know what the hell I'm voting for. It's like, okay, sure, save the firefighters, I don't know, right? I think Kennedy's far too quick to ascribe bad motives to people, far too quick. And you see this a lot in his cases. I am much more willing to say that people are motivated by good faith and say that they're motivated by bad motivation. Maybe I'm naive, maybe I'm an optimist, I don't know. But I generally think people are good. Maybe I'm wrong about that. The alternative is that people might be motivated by mixed motivations, right? They might say, well, I like this because of reasons 1, 2, 3, and 4. Okay, maybe reason number 3 is bad, 1, 2, and 4 are good. How then do you disentangle that? Right? Are you calling me a bigot because I might have a bad reason but good reason as well? We just don't know. It's for this reason I have a tough time with the analysis in Romer precisely because we're talking about a state populace, right? Thousands, I don't know how many people voted, but I'm guessing in the thousands, tens of thousands, right? And we don't know why they did it. But Kennedy has no doubt they did what they did. But yeah, I see your point. There was another case, which I don't assign anymore. I think it's in your supplement, which I didn't ask you to buy. But it's called Schuette, S-C-H-U-E-T-T-E, by, it's an acronym, by any means necessary, BAM. Yeah. It was an affirmative action case from Michigan where the people of Michigan approved an amendment to the state constitution that prohibited the use of affirmative action in education. This is post-Grutter, right? So Grutter says you can use race, right. And then the people amended the Constitution to say you can't use race anymore. Basically, the state constitution got rid of affirmative action. And a civil rights group called BAM brought a claim saying that this violates the same principle at Romer, that you're basically using the state referendum process to make it harder for one group of people, minorities and women, I guess, to change the law. That now, if a group of minorities wants to have affirmative action, they have to amend the state constitution. And they're basically adding requirements beyond what's in the Constitution. And the Supreme Court ruled in favor of Michigan. They upheld the referendum. And Justice Kennedy, I think, wrote the majority opinion. And there's some tension there with his opinion in Romer. I think there is. Because basically you had the people of a state amending the Constitution to target one group for disability. Now, I actually clerked when the Michigan case was going through the process, and I said, I didn't think Kennedy would go that way, and I think I was right in the hindsight, but I think you have a different analysis when it's the people voting versus the, but look, Tyler, in Obergefell, almost all the marriage laws were actually by referendum, right? Texas had one. When Kennedy says that a state's marriage law is based on animus, what he's basically saying is the people of Texas were bigoted, and that's why they voted for this law. It's people have actually understood how these cases work. It becomes a little bit uncomfortable, but he says it. Yeah, they're motivated by, how does Scalia say, the wild-eyed lynch mob, right? Mm-hmm. Scalia had some such phrase, talking about Bill Clinton, basically, Newt Gingrich. Yeah, but good question. Any other questions on Romer?
I have,
yes, Ted.
I'm not a lawyer, and this is the first time I'm hearing this discussion. How can a justice of the Supreme Court know what's in the hearts of minds of men when they go to the polls? It's just what you said.
Yeah. The question is, how can how can a judge, a justice, know what's in a person's heart of hearts when they go to a polling booth? They can't, but they try to do something else instead. They say, well, what could this law possibly be motivated by, right? And they say, well, if they were actually motivated by protecting people's freedom of conscience, they would have made the law more narrow. But because they made the law so broad, and what we say, not narrowly tailored, it's a very broad law, then the presumption is they weren't actually trying to fix this one little problem. They were trying to address a bigger issue, which was they didn't like gay people. But it's impossible to actually know what's in a person's heart, I think especially when you're talking about voters for a referendum versus members of Congress. But as a general matter, I'm skeptical of the Kennedy approach of always trying to find bad purpose anywhere. I mentioned the Masterpiece Cake Shop case, right? The baker from Colorado. Why did they rule for the baker? Because there was one member of the Colorado government who made comments disparaging religion, who said something like, using religion to justify excluding people is like the Holocaust. He basically drew analogies between Christians and Nazis. Okay, fine. Did that taint the entire proceeding? I don't think so. But it's Kennedy's approach. He always thinks, aha, I don't need to decide big issues. We'll just focus here on these narrow questions of what a person's intent was, which I think I'm not a fan of that approach. It's hard to know why people do what they do. Most people act for multiple justifications. They don't act for one reason alone, right? If you go to a restaurant, well, I like their food, but I don't like their desserts, but it's close, but there's easy parking. You balance stuff. You think of different reasons why you do something. No one is so singularly focused. Well, not everyone, but most people are not so focused on one issue alone. There's some people who are, but most voters aren't. They don't care enough to have that sort of fixation. Whatever, this seems reasonable. That's how I approach law, but what do I know? Okay, any other questions on rumor? Alrighty, let's move on to the next case, which is, again, from right here in Houston, Harris County, right? I'll do the facts because the facts in the actual case are wrong. And actually, a couple of years ago, one of my students who sat right over there, well, not this room, but sat in this side of the room, his either father or uncle was a member of the Houston Police Department. So he actually knew about this. He told me that I was right, that the actual account I'm about to give you was more or less correct. So the standard account is that in 1998, 4 sheriff deputies from the the Harris County Police Department, were called to a house for a report of a gun disturbance, that someone was waving a gun. They entered the apartment, they identified themselves, and they found 2 men, Garner and Lawrence, engaging in anal sex. All right, that's the story. The story then was that they were drinking, and then Lawrence was particularly aggressive. The lead deputy had options. He could have warned them and let them go. He could have issued a citation, or he could arrest them. He chose the third option. And that set Lawrence v. Texas in motion. Did I give you the video of the Lawrence yet?
Yes.
I'll play it for my parents then. This is one of our... Here.
Lawrence. Justice Kennedy offered this account of the facts.
In Houston, Texas, police officers were dispatched to a private residence in response to a reported weapons disturbance. The officers observed Lawrence and another man, Tyrone Gardner, engaging in a sexual act.
They just yelled, threw me back on the couch. It's just all of a sudden, we're taking you downtown. Their version of the story was that they had found us engaging in sex. They did not search anything to find a gun.
A majority.
They weren't actually apparently having sex. There were 4 officers. One recalled oral sex, one recalled anal sex, and the other 2 weren't sure. Sorry, Mom. You can't confuse the two acts. You can't. The cop was basically trying to trump up charges. They arrested them. The judge suspected that the officer just made up the charges. But they brought the charges forward. Lawrence and Garner, John Lawrence and Tyrone Garner pleaded no contest, which basically means we don't accept the charges, but we're not going to plead guilty. And then they were assessed a fine. At that point, the case was appealed up. The Harris County District Attorney, a guy by the name of Chuck Rosenthal, was in charge. He's an alum of this law school. He decided to make this his claim to fame, and he did inadvertently. He wanted to push this case forward to solidify its conservative bona fides. Everyone in the state was begging him, don't push this case, you idiot. Don't give the Supreme Court a test case on sodomy. Because after Bowers, there were just no test cases. No one got arrested for this thing. This is a crime that basically just never went punished. It's only by the freak chance of time that this case even went forward. He decided to push this forward. And then he decided to argue it himself with the Supreme Court, which was a mistake. At the time, we had a Solicitor General. His name was Ted Cruz. He was very good. He could have argued the case. Cruz was fantastic, much better lawyer than senator, but he was fantastic. Sorry, and I work for the damn guy. What do I know? But he decided to argue it, and it was really bad. If you ever want to listen to it, go to OYEZ, O-Y-E-Z, which has all the Supreme Court argument, and just pull it up, and he was just terrible. And I feel bad, because he starts emailing me recently. He emails me all the time, asking me questions. I don't know how he found me, but now I'm on his listserv. He emails me questions all the time with all these other people. I don't know who these people are. But this gave the Supreme Court a test case. And it turns out that the facts are a little bit more lurid. Apparently, Garner had not clear, but the guy who called the cops was interested in Garner. And it seems that the guy who called the cops wasn't happy Garner was with Lawrence. So basically, he called in a gun disturbance, and he said the black guy has a gun. So he was trying to get Garner in trouble for stepping out with Lawrence. So the facts are, again, very not clear, but none of these facts matter for the case, right? Justice Kennedy was irrelevant, right? This is about love and dignity. And when you actually know the facts, all this. When I read a Kennedy opinion, it's like a rejected Hallmark reading card. Just these sort of, or like a B+ paper in Philosophy 101. It's bad. But all this about love, if you actually look at the facts, these guys were, stepping out on someone else, and you had the racial element. You had a black guy with a white guy. I mean, there was a lot going on here, and I have to imagine that's part of the reason why they chose to arrest him and trump up these charges. All right. Yeah. At one point, the lawyer, Rosenthal, was giving a really bad answer, and Scalia told him, "Don't fall into that trap." And at one point, the lawyer was so bad that the justices started arguing amongst themselves, and Chief Justice Rehnquist said, "Maybe we should go through counsel." And at one point, Justice Breyer, who's the most calm person you'll ever meet, said, "I would like a quote straight answer from the lawyer." Okay, look, if you're ever in front of a judge and the lawyer said, and the court says to you, "I want a straight answer," you're not doing a very good job.
Is Breyer making a pun?
Oh boy, stop it. Oh God, at one point Ginsburg asked Rosenthal, "Does Texas bar gay people from adopting children?" His response, "I don't know." It was just really bad. At another point, Chief Justice Rehnquist said, "I don't understand your argument." Rosenthal was interviewed afterwards. He said, "I didn't do as well as I'd liked," but he said that Texas had a great brief, which he didn't write. I think the brief was written by Cruz. I think Don Wilt was on it also. Don Wilt is the Fifth Circuit judge now. Let me show you this picture of, where is it? I have a picture of them actually. This was from shortly thereafter, but you'll see the where is it?
Get it?
Yeah, so this is Attorney General Abbott in the middle. He argued another case, Van Orden v. Perry. Oh, you can't really see it. That's Ted Cruz, and that's Don Willett in the back. Like senator, federal judge, governor. It's a pretty remarkable picture. They all wound up in pretty high places. Yeah, Morales just got appointed, I think, in Corpus Christi somewhere else. All right, I'm done. I think Lynn's here next. Kennedy begins. Liberty protects the person from unwarranted government intrusions into a dwelling or other private places. Freedom extends beyond spatial bounds. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, certain intimate conduct. The instant case involves liberty of the person, both in its spatial and in its more transcendent dimensions.
What does that mean?
Please, enlighten us.
So that not only is your physical liberty, your home and your person protected, but also your liberty as in what you choose to do with your life is also protected?
Yeah, Dad, he says liberty extends to transcendent dimensions. What does that mean?
So not just...
No, it's a question for Dad.
It's beyond.
They meditate, they do this stuff.
These are your own values, your personal values, morals. These are items that are deeply held beliefs. So they're saying liberty. I'm surprised does that still exist? That design.
Well, he retired.
Extends to those beliefs?
He retired, so not really. Right. So the idea of transcendent dimensions is, I think, Lindsay and Dad both stated it well, that your freedom is not limited to your physical restrictions. Right. That you're not. It's not only about being locked up in prison. That involves something greater that goes beyond yourself. And here he discusses effectively the concept of love, right? That being with someone else is essential to your dignity. And it's not about the right to engage in a specific sexual act, right? It goes far beyond that. And this is where Kennedy disagrees with Bowers, right? Bowers defined the liberty at stake as merely the right to engage in sodomy. He says, no. That's wrong, right? The liberty is something much greater. It involves the right to define yourself, who you are, in transcendent dimensions. And the state cannot interfere with one's ability to define who he is. Okay, any questions on that?
Was that not essentially Justice Blackmun's dissent in Bowers?
Very close. In fact, Justice Blackmun, it was actually Justice Harry Blackmun, M-U-N, no relation. But Justice Blackmun used that phrase, spatial boundaries, exactly. I think he cribbed from Blackmun. Good connection, right? And he talks about, liberty and the ability to define your existence. He says that Bowers demeans the couple. It's not just about sex, right? The most private human conduct.
So would that hold up today, or we don't know?
Well, this case is about 20 years old, so I don't think this one's going anywhere. But he writes, the laws seek to control a personal relationship, and that the formal recognition of the law doesn't matter, but it's the liberty of persons to choose who they're with. States cannot define the meaning of relationship absent injury to a person. Adults may choose to enter the relationship that confines their home and retain their dignity as free persons. When sexuality finds overt expression in intimate conduct with another person, the conduct can be but one element in a personal bond that is more enduring. The liberty protected by the Constitution allows homosexual persons the right to make this choice. Okay, there's your greeting card, right? That's your B+ philosophy paper. Let's talk about law, right? So, Chelsea, generally, is this a substantive due process case or an equal protection case? What is Kennedy's opinion here?
It seems like it's more substantive due process.
Okay, good. So what then is the liberty that's being protected? What is the right at issue?
Privacy.
Is it privacy? Is it marriage? What actually, what is the liberty interest that Kennedy's protecting? It's not sodomy. We know that much. You said it's not sodomy. So what is the a liberty that Texas's law infringes upon?
Like what they do in their private lives and
Yeah.
deciding.
What's a word that Kennedy might use to describe that? Begins with a D. And don't even tell her. Oh, God.
I don't know why am I blank.
Dignity. Yeah, dignity. It's a sort of what?
Choice.
He doesn't use the word choice. Even in the abortion case, he doesn't talk about choice. He talks about liberty and dignity.
Well, isn't a part of liberty having the right to choose, to make a decision?
Of course, right? People can choose who they're with, but the frame he uses is dignity. And he effectively says that being able to choose who you're with is essential to defining who you are as a person. And if you can't make that choice, then the state intrudes upon who you are. Okay? So we have a substantive due process case, and the right is some sort of dignity of some sort, exactly. The details are nebulous, but we have dignity, right? Audrey, generally, what's the court's approach to deciding due process cases? What's the framework the court usually uses?
Is it the two-step?
Very good. And what's a two-step? What's the name of the case that's from? You're chewing. You can finish chewing. It's okay. Take a
But,
fish.
I think it's actually from the case Glucksberg.
Very
I
good.
haven't read, but
Right. We talk about it though, right? And what is that framework, right? Just describe it for me generally.
First, the court will narrowly define liberty carefully, so it's as specific and concrete as possible. And then two, then they'll determine that if that narrowly defined liberty is deeply rooted in our nation's history or tradition.
Okay, very good. Thank you.
But here Kennedy kind of does the opposite.
Yeah. So we have this framework, right? This Glucksberg Framework, which says that generally courts will be hesitant to recognize unenumerated rights. Why? Lochner, right? Lochner-phobia, right? God forbid the courts recognize an unenumerated right, because that leads right back to Lochner. We can't have Lochner, because Lochner's evil. So Glucksberg was a reaction to Lochner. And Glucksberg says we only focus on rights that are deeply rooted in history and tradition. And to decide what that right is, we have to narrowly define it. Right? The ball game's in the second test. Because depending how broadly or narrowly you define a right, you decide whether it's deeply rooted. If we say the right at issue is homosexual sodomy, then that's easy. There is no deeply rooted right to homosexual sodomy. But if we say it's the right to choose who you love, right? Choose who you want to be with. All you need is love, right? We just play a Beatles song to make that the right. That's easy. Of course, there's always a tradition that you can be with who you love. So the ball game's in step 2. And the big change in Justice Kennedy's opinion is he says, we're not talking about gay sex. We're talking about the dignity you get from love. Right? Love is just a, never mind.
He's reading a lot.
That's true. No, it's there. It's there. It's all about love. He writes, our obligation is to define the liberty of all and not to mandate our own moral code. All right? Once you break past that definition, it doesn't matter there's a long history of banning gay sex. He says, well, what matters most is what happened in the last 50 years. Right? Modern rights. Not rights that exist at the time of the framing of the 14th Amendment, but understandings that are fairly recent. He refers to the emerging awareness that liberty gives substantial protection to adult persons in deciding how to conduct their private lives. He cites the American Legal Institute and how states have repealed their prohibitions on homosexual sodomy. And he talks about Casey, right? Casey reaffirmed the liberty protected by the Due Process Clause. So even again, a decision he wrote, you're noticing a pattern. He writes all these cases, he keeps citing himself, right? Can you imagine how powerful it must be that you can write a decision and then cite it later as evidence for why you're right? You wrote it, right? It's all you, right? It's just Kennedy, 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 Kennedy. Is it in this video of all the Kennedys? No, it's in, I think in Windsor. Did I give you the Windsor video yet? I can't. Do you have it? I can never remember which one I gave you. It's my favorite scenes in the entire catalog. I'll play it now.
In the 3 decades from Bowers to Obergefell, Justice Kennedy wrote each of the major decisions extending the rights of gays and lesbians.
Yeah, I mean, it's him, right? That's it. And he's gone now. All right. I think that's all I want to say. Oh yeah. Then the court gets to overruling Bowers. And here we have some tension, right? Because we just had Casey, which had this really long discussion of stare decisis, right? We don't overturn precedents lightly. Tyler, how does Justice Kennedy justify overruling Bowers, 17 years after it was decided, but Roe v. Wade has to be set in stone? How does he justify this distinction?
That the way that it was framed, the specificity of one interest that was purported to be fundamental in Bowers was not the broader concept of liberty to now include dignity that he's focused on here.
Mm-hmm.
Roe, I think, would have been, I mean, as Justice Blackmun also mentioned in Bowers, if there was a platform for stare decisis on that case, this one could have been it more appropriately than this new, more artistic language that we had.
Artistic language.
Very good. Very good. Thank you. You talked about reliance interests, right? That people haven't relied on Bowers or very few prosecutions for sodomy, whereas there's extensive reliance in the abortion laws. He also, I think, generally thinks that decisions that promote liberty as he sees them are good, and decisions that restrict liberty are bad. So I think he has no problem overruling a decision that restricts liberty, but does have a problem overruling a decision that promotes liberty. So whereas he sees Roe as being pro-liberty, that's okay, but Bowers is anti-freedom, that's not okay. I think that also helps explain Kennedy. For him, it's a, on a sailboat you have a ratchet, right? It only turns one way, right? I think that's how Kennedy views law, that law always turns forward towards some sort of conception of liberty as he sees it, but you can never turn it backwards. So you can go forward away from Bowers, but you can't go backwards towards Roe. I think that explains in large measure how he approaches law.
Sir, is Justice Breyer gone at this point?
Breyer or Blackmun?
Breyer.
No, Breyer's been the course since 96. He's there. 96. He got 1994. Sorry.
Okay, so I mean, we didn't have any discussion, it appears, on the burdens benefit analysis.
Oh boy, yeah. I mean, Justice Breyer, he's a unique guy, and I think it's fair to bring that up. But he's very much about deferring to the democratic process unless it involves abortion. That's sort of just like an exemption to his existence. And there's certain.
That where was that in Romer?
No. Again, Breyer has a very strong deference. Well, let me explain it like this. For about 20-something years, Justice Kennedy was almost always the fifth vote. And when you're the swing vote, you get to write the majority opinion. And when you write the majority opinion, the other 5 in your majority are hesitant to disagree. And they're hesitant to write separately because they don't want to alienate you. So basically, they go along with whatever you write. One of Justice Scalia's most famous footnotes was the fortune cookie one. No, not fortune cookie, the paper bag one, where he said, if ever there was a price to pay for a fifth vote, I would put my head in a paper bag. They should be embarrassed. Look, Ruth Ginsburg could have written this opinion tight, right? Stephen Breyer could have written this opinion tight. But Kennedy does this sort of fluff, and there's this and there's that, right? And they just go along with it. There are no concurring opinions, right? A Obergefell, my God, I think Kagan could have written a really sharp majority opinion of Obergefell that would have been easy to understand. But they don't, because they didn't want to piss off Kennedy. They just went along with whatever he said. That doesn't exist anymore. But for 20 years, you never had a concurring opinion. Not in Romer, not in Lawrence, not in Windsor, not in Obergefell. Right? I think Kagan could have written an excellent Obergefell majority opinion, but that wasn't hers to write. She could have said, well, all this stuff at dignity is good, but let's talk about strict scrutiny for a few minutes, right? Let's talk about fundamental rights. Let's talk about equal protection. Let's talk about something law. Ginsburg, I think, could have done that very well.
Did O'Connor concur?
Well, she concurred in the judgment. And let's go. Actually, yeah, okay. I'm done with Kennedy. Let's move on.
Because she talks about the equal protection.
Yeah. Thank you. Now, O'Connor concurs in judgment. And O'Connor has... Oh, I'll do O'Connor 1 minute. One more point. At the very end, Kennedy says, this opinion does not involve whether the government must give formal recognition to any relationship that gays seek to enter. What's he talking about? Marriage. He is throwing this sort of barb at the end, saying, this is not about marriage, I promise. Pinky swear, right? This is only about sodomy. No one believed that, right? Even the biggest defenders of Lawrence don't believe that, right? This is what I mean when the other justices just hold their nose, right? You knew how Ginsburg thought about this. There's no doubt in your mind. But they just hold their nose and say, okay, whatever, it's a fifth vote, paper bag. Okay. But let's go into O'Connor. Justice O'Connor had a tough spot here. Why? She had joined the majority opinion in Bowers 17 years earlier. She wrote that, or she at least joined Justice White's opinion, which said that the state of Georgia could criminalize sodomy. She could have just come out and said, I was wrong. How bad choice of words. She could have just said Bowers was wrong. She didn't. Instead, she drew a distinction. She did not rule based on the due process clause. She ruled based on the equal protection clause. And she drew this distinction, right? The Georgia statute prohibited all types of sodomy between gay and straight couples alike. The Texas statute, in contrast, only criminalized homosexual sodomy. So if a man and a woman engaged in these acts, it was fine. But if two men, or I guess two women, engage in the acts, it would not be okay. So she found that this violates the gender discrimination case line, like United States versus Virginia and Frontiero and Craig v. Bourne. But even there, O'Connor seems on board with Kennedy, where she says that moral disapproval is not a rational basis. Yet she joined Bowers, which held that moral disapproval was a rational basis. So after this entire O'Connor opinion, O'Connor's at war with herself, right? She knows exactly what she did, and she just can't admit she was wrong. She did this a couple times. Another case called Kelo v. New London, right? This was a case about eminent domain. She had written the majority opinion 20 years earlier that said this was fine. And then she said, never mind, this is different. She couldn't admit she was wrong. We're all human, right? People don't like admitting they're wrong. I don't have that problem. I'm not all the time. Consistency is overrated. It really is. What's the expression? Consistency is a hobgoblin of small minds. Get over yourself. You were wrong. hell, even this class, year to year, I teach it differently. If you watch my old videos, I'll say something the exact opposite of my opinion. I really, yeah. But just they have to maintain consistency to the end of the world. But yeah, OConnor is a tough one. And at the very end, OConnor says, unlike the moral disapproval of same-sex relations, other reasons exist to promote the institution of marriage. What are those reasons? She doesn't say. But she basically leaves open the door, cracks it ever so small, that maybe you can have a ban on gay marriage, but you can't ban gay sex. Why? She doesn't say. But she's like, not my problem. I'll deal with it later. No, she won't be off the court. But yeah, she had a tough time here. Justice O'Connor, by the way, she's in her, should be, how old is she now? Should be 90? 89. Born in El Paso, actually. She's more or less withdrawn from public life. She has dementia, and she is basically withdrawn from private life, which is a sad thing. Mom, I'll tell you this story because I told my kids this already. But Justice O'Connor and Chief Justice Rehnquist, they dated.
I know, I saw the show.
But apparently, you know that Rehnquist proposed to her.
He proposed to her,
And she rejected her. But then the later part that became sad is in 2005, O'Connor's husband became afflicted with Alzheimer's. And she retired from the court prematurely to take care of him. After she retired from the court, her husband's condition advanced, and he forgot who she was. And he actually found a girlfriend at the home where he was living. Now she's suffering from dementia as well, so it's sucks, right then? You know. All right. Anything else on O'Connor? Yeah, Audrey.
I have a question on why that the gay and lesbian community is not or I guess they consider them to be the politically
Discrete and insular minorities. Is that what you're thinking
yeah,
of?
why are they a part of, just like in Claiborne, like why are they a part of that group?
Does the majority say that they are discrete and insular?
I don't think so.
No, they don't. They could. The Colorado Supreme Court, for example, said they were. But the Supreme Court doesn't. Justice Kennedy doesn't actually use Carolina products. It's not important to him. For him, it's all about animus and hatred, not about insular. I mean, let me make this point. The entire point of a discrete and insular minority is a bit of a, it's misleading. Let me explain it like this. If you have a large group of people and they have a lot of interests, it's hard to get them to unify around any one cause. But if you have a small group of people who are oppressed, there's one issue that really animates them. And they can focus their resources on advocating for that cause. And Scalia had this line where he says, with the homosexual agenda, he's referring to the idea that gays and lesbians, although they're a small number, they're fairly influential. And they were extremely influential in changing public minds on gay marriage, even in my own lifetime. So the entire idea of discrete and insular minorities never made much sense to me. It might matter if they can't vote, but the fact that a group is small doesn't mean that they're ineffective. Yeah. Sometimes, in some contexts, small groups can be even more effective than large groups because they're focused on a specific cause, and they can target the resources accordingly. Bruce Ackerman, professor at Yale, has written about this issue at some length. He says it's not discrete and insular. It's, oh God, I'm blanking the phrase, but it's disagreements. Okay. Anything else on O'Connor? All right, who's next? Lindsay, are you next?
Maybe.
Okay, fine, you're next.
That's fine.
I got a 1 in 4 shots. I take those odds to Vegas. Walk me through Scalia. Scalia, he was pissed in Romer. Now he's really pissed because, it's like, I told you so, right? But just walk me through the Scalia, please.
He said the court was simply making up a constitutional right, and that they ignored Glucksberg, and that since the court did not find that homosexual sodomy was a fundamental right under the Due Process Clause, it should not have been subjected to the standard of review that would have been appropriate. And then he also found that laws that are are immoral and unacceptable or problematic. Pretty much that if this was allowed, then things like bigamy, adultery.
Yeah, I got you.
Would
Problematic.
it's a legitimate.
To the contrary, expressing disapproval of immoral conduct, he observed,
is the same interest furthered by criminal
You're
laws
welcome.
against fornication, bigamy, adultery, adult incest, bestiality, and obscenity.
I always said bestiality. What do I know? Thank you. Yeah, Scalia's livid here, and he's making a number of points which I think are often discarded by sort of inflammatory language like this. You know, this is like the 3 generations imbeciles are enough type language that Holmes used in Buck v. Bell. This is Scalia's like 3 generations imbeciles. He had a point, but he just makes it in such a manner that it pisses people off. They don't see it. First, he says, "What the hell, stare decisis?" Right? We keep Roe, but we get rid of Bowers. How does that make any sense? Then he says the court failed to follow the usual approach to constitutional law. Right? They did not identify a fundamental right. They reviewed this law with rational basis scrutiny. And there's plenty of rational basis here, which is moral disapproval. Then Scalia walks through the notion that this decision can be limited to, gay sex, sodomy. What he says is this decision has dismantled the entire basis on which moral-based laws can exist, right? That if you can't prohibit certain acts because you find them immoral, then in every case where you legislate based on morality, the government's acting irrationally, right? And once you dismantle this, you're on a straight shot to overruling laws on gay marriage. You can't have them. Let's see if I have the quote here. Is it?
Do not believe it. Today's opinion dismantles the structure of constitutional law that has permitted a distinction to be made between heterosexual and homosexual unions. If moral disapprobation of homosexual conduct is, as the court says, quote, no legitimate state interest, close quote, what justification could there possibly be for denying the benefits of marriage to homosexual couples exercising what the court in today's opinion calls, quote, the liberty protected by the Constitution?
Justice Scalia's prediction would prove to be accurate.
Yeah, he was right. But once you get over that hump, that moral disapproval is not a rational basis, then lots of laws which we've had in the books for a long time go away. And it's not just in the context of gay marriage, incest, right? I've used this example before. It's non-trivial, right? If you have consenting adults, not children, I'm putting children aside, but you have consenting adults, 2 brothers, who are we to say they can't have relations? These stories happen, right? Polygamy. This came up in a Bergefell where the lawyer, or I think it was Justice Alito, maybe Roberts, asked the lawyer, why 2 and not 3? And she didn't have a good answer. Indeed, there's a much stronger historical basis for polygamy than there is for gay marriage, right? There's less societies today in the world that have polygamous marriages. If you notice when you read a Bergefell, Kennedy always says a pair, a couple, 2. Those words are there quite deliberately. But frankly, those are fringe issues, right? There aren't too many advocacy groups saying we need laws allowing incest and we need polygamy, right? These are sort of fringe issues, whereas gay marriage is a fairly prominent issue, so maybe that's the response. But Scalia, I think, articulated exactly where the law was headed in his Lawrence dissent. Okay. Questions on Lawrence? When I went to law school, Lawrence was somewhat new. It was only been 5 or 6 years old. So that was all we had. It's strange with this class where every time I teach it starts getting a little bit longer and longer. Where when I went to law school, there was just Lawrence. And then when we first started teaching, Windsor had not yet been decided. I think Windsor was decided, I think, at the end of my first year of teaching. So I taught my first year of semester, we didn't have Windsor. Now we have Windsor, and then a couple years later you have a Bergefell, and then I don't know where it goes beyond that, but the class always changes. Anything else on Lawrence? All right, let's go to the next case, which is Windsor. It's a short excerpt that you have, because I don't think, Randy doesn't want to put in the book. I think it's important, but we disagree on some stuff, but we have a short excerpt in there. Chelsea, what was going on in Windsor? Just walk me through that, please.
So, DOMA Section 3 provided a single definition of marriage, which is one man and one woman. Obama administration concluded that it was unconstitutional and declined to defend it, but the House of Representatives intervened. House of Representatives justified that it would reflect and honor collective moral judgment.
Mm-hmm.
The Solicitor General denied that and said that it only had one purpose, which was to exclude same-sex marriage, lawfully married couples from federal benefits. Do you want me to go into
No, that's good. Thank you, Chelsea. Appreciate it. Windsor was a weird case. And it was a weird case because the government agreed with the plaintiffs, right? Edie Windsor was in a long-term relationship with Thea Spire, two women. They were married in Canada, but at the time New York didn't allow them to get married. Spire died, and she left her entire estate to Windsor. Generally, when you're the surviving spouse, you get an exemption for estate tax. But because they were not married, they were denied the exemption for the surviving spouse. So the case actually arose because Windsor wanted a refund, about $300,000 tax refund for whatever tax she paid. The IRS denied her the refund. During the course of the litigation, the Obama administration said, aha, we will not defend DOMA. We've determined that DOMA is unconstitutional. They wouldn't just give Edie her refund, right? They kept the controversy alive, so to speak, although the standing argument's a little bit dicey. But they said, we're not giving a refund, and that ensured the Supreme Court would review the case. The entire issue in DOMA turned on whether the law had a rational basis. And Chelsea, a few moments ago, correctly stated the rational basis for the law. The rational basis of the law was moral disapproval. And remember, this was decided at the same time Romer was. At the time, Bowers was good law. And the members of Congress thought so. So let me play this colloquy, right? There was one exchange between Justice Kagan and Paul Clement, who was the lawyer for the House. By the way, because the Obama administration did not defend it, the House intervened. And Kagan's basically saying, what's the basis of treating gay and lesbian marriages different than straight marriages?
Differently. A colloquy between Justice Elena Kagan and Paul Clement foreshadowed the outcome in Windsor. Justice Kagan observed that in 1996, the House of Representatives explained that DOMA would
reflect and honor a collective moral judgment
and express
moral disapproval of homosexuality.
In other words, the reason why the law treated gay marriages differently is because they disapproved of homosexuality. Right? This was the same interest at Bowers, the same interest in Lawrence, the same interest in Romer. Is that enough?
She then asked Clement,
is that what happened in 1996?
Clement replied,
of course the House report says that, and if that's enough to invalidate the statute, then you should invalidate the statute.
He then countered,
but that's never been your approach, especially under rational basis or even rational basis plus, if that's what you're suggesting.
Current Solicitor General Donald Verrilli declined to defend the law. He argued that there was only one purpose behind DOMA.
The House report makes this glaringly clear, is that DOMA was not enacted for any purpose of uniformity, administration, caution, pausing, any of that. It was enacted to exclude same-sex married, lawfully married couples from federal benefit regimes based on a conclusion that was driven by moral disapproval.
Chief Justice Roberts interjected,
That was the view of the 84 senators who voted in favor of it.
In other words, if you're saying that this law is motivated by animus, then that's a view held by the 84 senators who voted for it and President Clinton who signed it. Were they motivated by animus?
Who signed it? They were motivated by animus.
In a 5-4 decision, the court would find that Congress and President Clinton, in fact, were motivated by animus.
All right, so that's the upshot of Windsor, and that's basically the entire ball game, right? Once you say that disapproval of homosexuality is not a rational basis, this is an easy case. Lawrence came very close to saying that, but didn't quite say it, right? Windsor said it. And then once you remove moral disapproval as a rational basis, the gay marriage laws don't stand a chance. Right? The laws banning gay marriage were enacted primarily because people thought those relationships were not entitled to respect, that these people were engaging in immoral conduct and they should not be sanctioned by the state. Once you remove that barrier, to use Justice Scalia's framing, you dismantle the structure of constitutional law that permits differentiations to be made between gay and non-gay marriages. And that's the majority. I mean, that's it in a nutshell. There's not much more to say about it. Scalia's livid. This is one of my favorite Scalias, so I'm just going to play a little bit about it. Where do I start? I'll start here.
Pin down the precise technical legal basis for the majority's conclusion of unconstitutionality.
The majority did not apply strict scrutiny to protect a fundamental right. Instead, the court took a different approach.
The majority opinion makes clear that what causes DOMA to be unconstitutional is the fact that it is motivated by, quote, the bare desire to harm, close quote, couples in same-sex marriages.
Justice Scalia would
require the most extraordinary evidence
before charging that, quote, Congress and the presidency of the United States were
unhinged members of a wild-eyed lynch mob.
To the contrary, he contended, there was
perfectly valid justification for this statute. Imagine a pair of women who marry in Albany and then move to Alabama, which does not recognize as valid any marriage of parties of the same sex. When the couple files their next federal tax return, may it be a joint one? Which state's law controls for federal law purposes? The state of celebration, which recognizes marriage? Or their state of domicile, which does not? DOMA avoided all this uncertainty by specifying which marriages would be recognized for federal purposes.
Instead, Justice Scalia observed, the majority saw a very different purpose behind DOMA.
To disparage, injure, degrade, demean, and humiliate our fellow human beings, our fellow citizens who are homosexual.
He concluded,
it is one thing for a society to elect change. It is another for a court of law to impose change by adjudging those who oppose it hostes humani generis, enemies of the human race.
If you haven't taken property yet, one of the first cases you study will be Pearson v. Post. Remember that case? The Fox case?
Yep.
The judge in that case refers to foxes as hostes humani generis, because the foxes are the enemies of the human race. And Scalia used that phrase. His father was a Latin professor at Brooklyn College, so he knew these things. Okay. All right. That's why I wanted to play the audio, but I think the Scalia opinion captures his flair pretty well. But Windsor, I think, was mostly like a pit stop on the way to Obergefell. All right. Any questions on Windsor?
Where was the legislature on this? It's the executive and judiciary deciding how to interpret and whether or not to enforce a law. Why no congressional act if that was the intent?
I'm not sure. Well, the House defended the law in court. I think you're asking something else, though.
So,
Congress enacts lots of laws, right?
right,
But in this case, the executive branch said we're not going to enforce. Well, to be precise, they enforced the law, but they would not defend it in court.
okay, that's,
In other words, they did not give Edie her tax fund, her tax refund, but they continued to enforce it. They wouldn't defend it in court, though.
so it's not as simple as President Trump saying, Affordable Care Act, I'm just not gonna enforce that.
Right. So that's the analogy in the present litigation. The Trump administration has said we will continue enforcing the ACA. We will not defend it in court. And actually, to be precise, they're defending they're defending a few parts of it, but not all of it. So it's actually different. The Obama administration wasn't defending any aspect of Section 3 of DOMA, whereas the Trump administration wants parts of the laws to survive.
Why do you think the federal, the commerce side of it and the taxes made absolute sense? I'm curious, how, and this may be a bigger discussion, but why do you think, if that's the intent, if that's the basis, they arrived or they used the nomenclature they did to describe it?
Moral disapproval, you mean?
Defense of marriage. If it's really about commerce and taxes, why did they call it that?
Oh, no, it was about defending marriage. Let me explain. At the time, I think the Hawaii Supreme Court had started to recognize that the state constitution guarantees a right to same-sex marriage. Or they didn't call it same-sex marriage, they called it domestic partnership, right? What happens if Massachusetts allows gay marriage and a couple gets married in Massachusetts and they move to Texas? Would Texas then be required to recognize it? Would federal law then require to give tax benefits to a gay couple who's married? In other words, once a single state legalizes gay marriage, then effectively that couple can move anywhere in the nation. Or they don't have to move. They can just take a vacation to Massachusetts, get married, and come back. Same way people go to Vegas to get married. Mm-hmm. So it truly was about defending marriage in all 50 states if a single state went the other way. Now, President Clinton signed this one very quietly. He signed it before the election. There are no pictures of him signing it because he was probably embarrassed about it. When Windsor was decided, he said, I screwed up. I shouldn't have done this. Now, at the time where Clinton claimed that he signed this to prevent a constitutional amendment to prohibit gay marriage, there's no evidence this actually happened. But Clinton signed this and it passed, I think, with 85 votes in the Senate. It was very popular. There were other aspects of DOMA, which I'm not going to talk about, but involve the full faith and credit clause, of whether Congress could pass law that says a state does not have to recognize a gay marriage from another state. That's an aspect of full faith and credit. Obergefell didn't have to resolve that issue because they found there was a right to it. It was kind of moot. But the court could split the difference and said, we don't have the right to recognize marriage. You don't have to give a gay marriage license, but you can recognize it from out of state. That could have been a middle-of-the-road approach, which the court did not take. All right, anything else on Windsor? Yeah, Chelsea?
So this is the case where they come out and say there's no disapproval.
That's not a rational basis. Yeah, this is it. Once Windsor makes that move, it's ball game over. Almost immediately after Windsor was decided, lawsuits were filed across the country challenging the gay marriage laws. The strategy was called, I can't remember who coined it, but I think a law professor or someone said, sue the bastards. In other words, in every single state with a gay marriage law, just sue them and hope it works. And all the judges in these cases thought they were so cute. They said, Justice Scalia was right. All right, once you remove moral disapproval, why can't you have gay marriage? Gay marriage, right? So basically all these judges who probably would vomit on Justice Scalia's grave, right, were just, I don't say that lightly, but they hate him so much, are using him as evidence that now we can have gay marriage. And they were right. Once you get past Windsor, it was I describe it as a train going somewhere. We all know the destination, just we don't know when it's going to get there. Right? You're going there, you just don't know how and when. But it's all winding up in a single terminal. Yeah, Jesse?
Would this case have to have been decided if we had the privileges and immunities clause still?
How so?
I mean, if you recognize someone as married in Texas, wouldn't you have to recognize them?
Well, are you asking about the Article 4 privileges and immunities clause?
I think so.
Okay, yeah. So the Article 4 privileges and immunities clause says whatever rights you give your own citizens, you must give to out-of-state citizens. So if a state, for example, allowed its own citizens to be married, then presumably they couldn't deny someone from Oklahoma from getting married.
Okay.
Unclear if marriage in this context was a privilege and immunity, but I think it probably would have been.
Okay.
A good point. All right, other questions on Windsor? Yeah, but Edie Windsor, by the way, is adorable. I love this picture in the.
She died, right?
No, I think she's still alive. No, her partner died many years. No, she's still alive. No, she died in 2017. Yeah, she died a couple years ago. So she died about 4 years after case was decided. Yeah. Okay. All right. Anything else on Windsor? All right. Let's go into the last case, which is Obergefell. And I have a little prop. James Obergefell actually came to Houston a couple years ago after his case was decided. It was right at Discovery Green, a few blocks away, and I went. Yeah, I don't know, whatever. And I told him, I'm a constitutional law professor. I asked him, could he sign my constitution? I just all the time. I have an entire book of signed constitutions. And usually I get them to sign, the beginning of it. But I said, what the hell? And I gave him the 14th Amendment part, right? And so would you sign it? So, I could walk around and show it to you all. But, he just wrote, underneath Section 5, Jim Obergefell, and he wrote, "Love wins." I'll pass around in a second. Love wins. And I was just sitting there like, it's almost like he basically added a section to the 14th Amendment, right? The love clause, right? The love connection. Love wins. And in many regards, Justice Kennedy transformed constitutional law with how he approached the 14th Amendment. And Obergefell is like the crowning achievement, right, of where all these four cases came together, where Romer, where Lawrence, and where Windsor culminated in Obergefell. It's actually my old one. I have new ones now. That's actually the old card. Yeah, I can do that. Yeah, you can pass these around. Oh, no, these are the old ones. I have the new ones here. The new ones are much nicer. Or I think they're nicer. Here. You can have one. 1, 2, 3. Oops. Okay. Yeah, I have an entire book full of signed constitutions. If you ever come to my office. Take these out. All right. Where else was I? Okay. So Obergefell was sort of crowning achievement. What makes Obergefell, I think, tricky for students to study is what kind of case is this? Is it a due process case like Windsor? Is it an equal protection case like Lawrence? I'm sorry. Is it a due process case like Lawrence? Is it an equal protection case like Romer? Right? Where exactly does this case fit in? And the short answer is a little bit of both. Right? A little bit of country, a little bit of rock and roll. It's both. It's a Lawrence tribe at Harvard described as a double helix, like a DNA, right? Where the due process and protection wrap around each other and protect each other. I don't know what that means, but tribe is far more eloquent than Kennedy is on that front. So let's walk through Obergefell. The first thing to note is it's 5-4. This was not this is not like Brown where the court found unanimity. This was sharply divided. And it was sharply divided on an issue of great social import, the question whether gays and lesbians have a constitutional right to marry. There's no surprise that Justice Kennedy wrote the majority opinion. There was some speculation that perhaps Chief Justice Roberts would join the majority and think of his legacy, right? Think of how people view him in 50 years. But he went along with this. He dissented. There were also 4 dissents. It's not common to have 4 dissents in a case. It's fairly rare. I don't think you have any other case like that this semester, where they all disagree with each other. And don't all join each other, right? They have different reasons for disagreeing. And I think Obergefell illustrates the entire spectrum of how the court approaches these issues, right? You get a very different flavor with each of the dissents. All right. Oh, here, people on YouTube. Oh, I don't buy phone numbers. Never mind. People are creeps on YouTube. They are. Okay. Who's next? I think Chelsea, you might be next. Sure, I don't remember. Audrey next? I don't remember. All right, Chelsea, then Audrey. So, Chelsea, walk me through Justice Kennedy's majority opinion. It's a little bit confusing, and if you were confused reading it, you know, I used to assign my students the entire opinion, over 100 pages long. I used to make this the last day of class, and I would assign the full opinion. You guys lucky about, 20 pages? But I used to assign the entire 100-something pages, which was brutal, but so now you got a little bit easier. So just Chelsea, walk me through the Kennedy opinion a little bit, please.
So he did not expressly overrule Glucksberg.
Oh, okay, yeah. So starting off, right? If we're talking about Glucksberg, we're talking about a due process case, right? So what exactly is the liberty interest at stake here, Chelsea?
Same-sex marriage.
Okay. Now, Chelsea, is there any argument that same-sex marriage is deeply rooted? Can you make that argument credibly? No, right? The entire idea of a gay marriage is novel, right? It didn't exist 20 years ago in any country in the world, right? It wasn't even a thing you could think about. So you have all these old cases that talk about marriage being fundamental to the very existence of mankind. You have Loving versus Virginia, right? They were all talking about a marriage between a man and a woman. There was no doubt. But Kennedy rejects the idea of Glucksberg. He says, history and tradition do not set the boundaries of due process. Rather, when new insight reveals discord between the Constitution's central protections and a received legal stricture, he wrote, a claim to liberty must be addressed. Marriage is not a fixed institution. The history of marriage is one of both continuity and change. Query, who made those changes? The elected branches of the courts. And he says recent decisions like Lawrence v. Texas have expressed broader principles. In short, he says the Due Process Clause protects a fundamental right to same-sex marriage. He says rights come not from ancient sources alone. Rather, these rights rise from a better informed understanding of how constitutional imperatives define a liberty that remains urgent in our own era. To deny these couples these rights would disparage their choice and diminish their personhood to deny them this right. And the court cannot violate this 14th Amendment right of fundamental liberty. And that's it, right? Again, this is not surprising from Lawrence and Windsor, right? Lawrence said we can't look to history to define rights, and Windsor said that moral disapproval is not a rational basis. Once you make those two moves, that rights are not defined by history, and you cannot enact laws based on morality, this is easy. Right? This is a piece of frickin' cake. So it's a walk in the park. You don't need to do a lot of work to get here. Yeah, I mean, I don't need to assign the full opinion anymore because now it's pretty obvious what's going on. Any questions on the due process analysis from Justice Kennedy? Now, if I can ask you, what's the test, right? What's the test for what's a right that protects dignity and personhood? You know, perhaps the saving grace of Kennedy opinions is they don't have any shelf life, right? How do you apply this to any other context beyond gay marriage? I couldn't tell you. The virtue of the Glucksberg test, if you like it or not, is you could apply it, right? You say, this right deeply rooted. Let's look at history. I don't know how to apply any of Kennedy's opinions, which is why I think that they will not have much lasting impact. I don't know how you extend this anywhere else. I think it's basically just like a blip in our constitutional history. And people will discard it. And I can make a prediction. I think Glucksberg's going to come back. I think the next due process case, the court just cites Glucksberg, says, look, we're citing it wasn't overruled, still good law, we're using it. And if you noticed, you didn't, maybe you didn't listen, but I did, when Justice Kavanaugh had his confirmation hearing, he was asked about how do you identify a fundamental right. He was like, Glucksberg did not mention Obergefell. And a lot of professors were like, wait a minute, he's not talking about Obergefell. I'm like, no, he's not. Because I see Obergefell is limited to a one-off. It's limited to gay marriage and nowhere else. I don't see its extension beyond that. Critically, Kennedy didn't even find that sexual orientation was a suspect classification. He didn't. His equal protection analysis is very difficult to follow. But he says the challenge laws burden the liberty of same-sex couples and they abridge the central precept of equality. But Kennedy just never talks about strict scrutiny. It just is not important for him. So effectively, we're left with rational basis scrutiny. You have a fundamental right for marriage, but nothing else. I don't know where this opinion leads in a couple of years. I don't know what lasting legacy it has. Right? So this is not like, a Robert Jackson opinion where we're studying for decades with the three zones, right? This is, McCulloch v. Maryland was a great substantive independent power. Wickard, what's a substantial effect, right? Is this economic activity? Is there a right to, is there an undue burden on abortion, right? These are tests that you can actually apply. I don't know what to do with the Obergefell. And this case is now, almost 4 years old. I still don't know what to do with this case. That's why I have trouble teaching. I think this is the hardest case for me to teach because I don't know what it means going forward. Like in our video at the last chapter, we say, so what do we say? We must await future decisions to see how the court resolves this. Yeah, I don't know. I don't know where this case fits. I knew it was going to happen, but I don't know how to place it in our history.
What do other professors say? That's important.
I think they celebrate. They think it reaffirms the dignity of gays and lesbians, and the results. I'll tell you what they say. There's a group of professors led by someone at Yale, and they're writing a book called "What Obergefell Should Have Said." Right? What this case should have said. And the premise of the book is the opinion is incoherent. Let's try and rewrite it if we were the justice. And I think even the most ardent supporters of Obergefell find it lacking. And they say it didn't clarify issues that are very important to gay and lesbian rights. They wrote another book called What Roe v. Wade Should Have Said, right? Because again, the Roe opinion is, people love it, but the opinion itself is not very cogent, not very clear. Right? There's a downside when you let Kennedy write this opinion, not someone like Elena Kagan or Ruth Ginsburg, who have written a stellar opinion. I think they could have nailed this. They could have said, strict scrutiny, done, clean, right? We're out, peace. You've done it with 20 pages. Easy, right? Classifications on the basis of sexual orientation are gender-based classifications. Fine, intermediate scrutiny. Exceedingly persuasive justification, moral disapproval doesn't cut it. Done. I can write that opinion in 20 minutes. Which is why I think Scalia was so livid, saying, you guys needed your fifth vote, and this is what you did. You basically sold yourself for this opinion. Even Judge Posner, who was a judge on the Seventh Circuit in Chicago, he wrote a circuit court opinion that I think is very neat and very clean, discussing scrutiny under equal protection. Suspect classification, done. Quasi-suspect, fine, done. Right? Read Judge Posner's opinion. I think Posner drove me insane, but I think he neatly explained the issue very well. Yes, Mom.
Once a decision is made, can it ever be updated?
They occasionally make mistakes. So sometimes they make typos, and they fix those without telling anyone. But occasionally they make factual errors, which they do correct publicly.
Not reword things or a better version.
The way they do it, Mom, is that in a future case, they'll say, well, here's what we said here, and here's another way of thinking about it. So they won't change Obergefell, but they might modify in later case how it's treated. Yeah. I think any of the justices in the majority could have written a much cleaner opinion that would have given clarity to the lower courts. But Kennedy was not concerned. He liked leaving things open-ended. That was very important to him. And I don't say this is, I think Obergefell reached the right result. I have no problem with gay marriage, but the opinion itself just left so much to be desired. Anything on the Kennedy majority? All right, let's walk through the dissents. Yeah, Audrey.
So as far as dignity for this whole entire Kennedy concept, does he define dignity just basically as the choice of in a person?
You know, the concept of dignity has a central place in European case law, right? I think the German Constitution, check me on this, I think the German Constitution actually says you have a right to dignity. So he's incorporating concepts of law that are foreign to our Constitution. We don't have a dignity clause. I think Justice Thomas says this, we have no dignity clause in the Constitution. But broadly defined, dignity is the right to define who you are in your own existence. But it's a very, yeah, B+ philosophy paper, yeah. Again, I don't have a philosophical background, so I don't get these issues of dignity. It doesn't resonate with me. Other people it does. I know the Constitution is the only fountain from which I shall draw. I mean, Justice Blair, but I don't know. I can't help you with dignity. Go take a Houston Community College class in philosophy. Maybe you can write a majority opinion for the Supreme Court. Yeah, I've never taken a philosophy class in my life. Maybe I'm ignorant. I don't know. I don't pretend otherwise. I couldn't get a B+ in that class. I think I once tried writing in philosophy in law school. I got a C. So what the hell do I know? I know the Constitution. It's in a Ziploc bag, keeping it safe. That's all I know. Okie doke. Anything else on Kennedy? All right, let's walk through the dissents. Again, there were 4 separate dissents. And Chief Justice Roberts, I think, begins with a good tone. He basically says, look, I don't begrudge, couples who can get married because of this. Right? We should celebrate people who benefit from this decision. And I think that strikes a very good tone, right? There are people whose lives improved because of this case, and I think we shouldn't lose sight of this. I mean, people ran to get married hours after the decision was rendered, right? And we should not lose sight of this. But for Roberts, it's not about the people, it's about the law. And he goes very quickly into saying, Lochner, right? Lochner phobia. Think of Kermit the Frog in the GIF where he's waving his arms like that. That's what I imagine with Lochner. Oh, yeah. That's, the GIF I'm talking about. Where is it? Yeah, this one. So whenever everyone cites Lochner, I just think of this. Yeah, Lochner. yeah. So Lochner the Frog. Yeah. Yeah. Next time I tweet out Lochner phobia, I'll just put that. Anyway, whenever I think of Lochner, that's what I think of. But Roberts is very much concerned with Lochner, and he worries that if we start recognizing rights, we'll just go back to Lochnerism. And he compares again Dred Scott to Lochner. You've heard this before. There's nothing new there. Roberts also faults Kennedy for not following Glucksberg, and Roberts says that Glucksberg was effectively overruled, but not quite. And I can be certain the next time the conservative majority cites Glucksberg, Ginsburg will cite that part saying, you said it was overruled. No. Or maybe we cake, and I don't know. Ginsburg may not be there next time. We'll see. It's changing class every year. Different law. Scalia wrote the second dissent, and he makes a point that I don't think is well understood. We often think of freedom in terms of rights. Can I engage in an abortion, or can I have gay sex, or can I do this or that, right? But Scalia says the most basic freedom is a freedom for which we fought for independence. And that is the right to govern ourselves. And if we can't govern ourselves, we cannot be free. And Scalia says that we've basically handed over our law to 5 lawyers, not judges. Roberts uses the phrase, 5 lawyers. That's mean, right? It's not 5 judges. These are 5 men with law degrees, or I guess 4 women and 1 guy with law degree. Oh, Breyer, 3 and 2, whatever. 5 people with law degrees who are ruling upon all of us. And Scalia even makes his barb saying, and we basically have a court that's all a bunch of people from New York, right? He says there's not a single true Westerner on the court. Sacramento doesn't count. Because Kennedy from Sacramento is like, that doesn't count. And he says Roberts is the only one from the vast in-betweens from Indiana. At one point, we had justices from 4 of the 5 boroughs, right? Scalia was from Queens. Ginsburg was from Brooklyn. Sotomayor was from the Bronx. Kagan was from Manhattan. And which borough was missing? Don't. See if they know. Which borough was missing? There were 4 of the 5 boroughs in New York.
Brooklyn, Queens, Manhattan, Bronx.
Yeah, what's the other one?
Staten Island.
Where am I from?
Staten Island.
I stand ready to help. But, of course,
Maybe you're next.
yeah, right. But Justice Alito's from Jersey, so it's close enough. Got it. But Scalia would mock that basically all the justices from the East Coast, they all went to Harvard or Yale. This is not a representative body that can make decisions for the entire country. All right, so Scalia was livid about this. He says, the court ended this debate in an opinion lacking even a thin veneer of law. This brings to mind Justice White's dissent in Roe v. Wade, where he says this is an act of raw judicial power. Any questions on the Scalia or the Roberts, for that matter? Dissents. Scalia was so pissed with this one. But, I think the worst one was either Lawrence or Windsor. I think by the time he got to Obergefell, it's like, he had come to accept it. Like the stages of grieving, right? Where first you're angry, and then you're in denial, and then you're in acceptance. I think by the time he got to Obergefell, he'd accepted what happened. I think Romer was the angry, and maybe Windsor was denial. I don't know which one, but he came to terms by the time we got to Obergefell. He got it. He recognized that Kennedy won and he lost.
Do you agree with Justice Roberts, the way that he distinguished Loving? I thought that was actually
Thomas or Roberts?
Roberts. He talked about the basis of it is being repealed upon white supremacy, as opposed to the rights to marriage components that the majority highlighted.
Oh, I see your point. Okay, yeah. In Loving, right? Were the Lovings seek to redefine marriage, or were they seeking to restore the definition of marriage, right? If you were to ask the Lovings, they would say that marriage was historically the union of 2 people, and the entire idea of miscegenation law was novel, right? That was an artifact of Jim Crow, which was designed to create a badge of slavery, to remind people about slavery, right? So I think Roberts is saying that Loving was about restoring the tradition of marriage, because in most states, you could get married to someone of the opposite race. It was only the Jim Crow laws that prohibited interracial marriage. Whereas here, every state only had heterosexual marriage. It wasn't any tradition of gay marriage. So Roberts says we're not trying to restore or unify a right, you're trying to create a new one. I think that's how he distinguishes Loving. I thought you were getting at Thomas. Thomas also talks about Loving, and he says there's a difference between a criminal law that's making it a crime to get married versus a right to get married in the first place. I think Thomas would effectively say that it's far worse to throw someone in jail for having a relationship between the races rather than saying there's a right to get married in the first place. So I think that Thomas makes that point also. That's not one of the stronger parts of the Thomas opinion. But I think Roberts probably the better argument. But to this, Kennedy would reply that marriage is a changing institution. It's not fixed in time. Which of course raises the question, who's responsible for changing this institution, the courts or the elected branches? But then he says when there's a fundamental right at stake, we can't wait for democratic change. Well, says who? Right. Says Kennedy. Right. It's basically he's citing himself over and over again to explain why he's right. It's, try winning an argument where the one person can say who's right and wrong, and that's we have Anthony Kennedy. But now we have John Roberts, so what do I know? We move from one dictator to another. You know, I'll say this, I prefer Kennedy as my absolute ruler than Roberts, because with Kennedy he had some values. Roberts is motivated by something, I don't know what. I knew it. I could predict what made Kennedy tick. He liked federalism, he liked liberty, he liked gay rights. I knew it made him tick. With Roberts, I don't know what make the guys tick. So I would prefer for my absolute ruler to have Kennedy over Roberts in a heartbeat. I mean that sincerely. I'm going to write that at some point this summer. But
It's already live streaming, Josh.
you know, if I you know, choose a devil you know versus the one you don't, right? I would choose Kennedy in a heartbeat. In a heartbeat, I would choose Kennedy, not Roberts. Not Kavanaugh for sure. Yeah, go ahead.
Now that Obergefell, Kennedy removed moral disapproval part of the rational basis. Should we only look at that when addressing like gay marriage?
That's a really good question. I don't know. And even if you were to ask me that in other contexts, right? We've had cases since Obergefell about polygamy. We've had cases about incest post Obergefell, and the courts have said, "Oh well, no, you don't have a right to have 3 wives. Just a wife the opposite sex."
That's exactly what I was.
There have been cases, and the courts have said, "No, we didn't really mean it. Just like limited to gay marriage." I mean, I want to tell you that Obergefell extends to other doctrines, but already courts are sort of cabining it, right? Putting it in containers, buckets, if you will. Yeah, but I take Kennedy over Roberts as my swing vote in a heartbeat. Problem is sometimes, you know, Roberts was always a swing vote, but we'll see. Thomas had the other dissent, or the third dissent, and he says that liberty is a freedom from governmental action. It's not a right to a license. And this is in response to the spatial dimensions of freedom, which I think Tyler pointed out, just as Blackman wrote about as well. For Thomas, liberty is not some sort of fuzzy right to a marriage license. It's a right to not be freed from governmental restraint. And he says there's no dignity clause in the Constitution. And he says the Constitution contains no dignity clause, and even if it did, the government would be incapable of bestowing dignity. And this made people very angry. For Thomas, dignity is something you're born with. It's an inalienable right from the Creator, whoever that might be. It's not something the state can bestow on people. Justice Alito had the final dissent. And he raises the issue of what you might call religious liberty or free exercise of religion. That this law will run afoul or run into people's free exercise rights. During the oral argument, I think it was Alito or Roberts, I can't remember, asked a question about what happens if you have a religious college that offers dormitories to married couples. And they'll offer a dormitory to a man and a woman couple, but the religious college will not offer a dormitory to a husband and a husband couple. And this should have been an obvious question. And apparently the Solicitor General wasn't ready for the question because no one asked him that during the moot, right? Because people only mooted him who agreed with him. And Verrilli said something like, that's going to be an issue, we'll have to deal with it later. Once you basically say that the people who back these laws are bigots, you then open them up saying that you cannot exclude from religious colleges opposite or same-sex couples from dormitories. There are lots of examples. But the Kennedy opinion of saying that these laws are motivated by animus is effectively saying that people who support these laws are bigots. They're no different than the Virginia police sheriff who threw Mildred Loving into the jail cell for the weekend, right? It's no different than the person who segregated the train car in Plessy, right? You're no different than the guy who threw Fred Korematsu in jail for not going to the camp, right? Once you sort of put this label of animus against people, you associate them with some very, very bad stuff, some very wicked stuff. And this is why I think the court could have done a Posner approach without going down this animus road, but Kennedy loves animus, right? He thinks the way to decide things by looking at people's heart and seeing how they feel about people. And if they have a bad, wicked, forget evil eye, even evil heart. And for that reason, you can say that they are out of bounds, they've acted improperly. Okay. Any question on the Obergefell dissents? Yeah, I think the Berryfold dissents. Anything else in general before I move on to the exam? I'll go over in a few minutes. Anything in your mind from the semester? I will not be, I mean, your exam's on Friday, for God's sake. It's so damn close. But if you need me, just email me and I can set up a phone time to call. I won't be here this week, but I'll be happy to answer your questions. If you just don't email me on Friday, please. Whatever questions you have, just get them by Thursday, the day before, and I'd be happy to, if I can answer by email, I will. Otherwise, I'll give you a call. Don't text me. I gave you my phone number. Please don't text me. It's very, never text your professor. Some professors actually ask you to text them. I think I don't agree with that. I think it's just you're getting yourself in way too much trouble. I had a student maybe a year ago who took my car off my desk and texted me, and I emailed him and said, please don't text me. If you want, you can call me. My office is a phone, but don't text me. Yeah.
I kind of have just a general question.
Yeah.
I had a friend that mentioned to me on a podcast, which I'm going to listen to, that this was all over the Constitution, and us as a country, there's no other country that puts as much stake in their Constitution. We have an entire court system to interpret what it says and all that. Do you have any thoughts about like why we do this and no other country really does it?
Oh man, what a good question. I don't know if I have a good answer why. I can say descriptively we have the oldest stable constitution. Now, some people would say the reason why our constitution has been so stable is the courts have largely ignored it and interpreted it according to their own philosophy. So in many regards, our constitutional government looks not that dissimilar from constitutional governments in Europe, which are fairly new. Right? So like, the sorts of things that our courts do are not that dissimilar to what other courts around the world do. So I would love to say that we are still operating under the same constitution that was sitting under the glass in the National Archives, which Nicolas Cage tried to steal, right? But that's not exactly the case. I don't have an answer. I think we have a commitment to the rule of law in this country that's fairly unique around the world. I couldn't tell you why that developed. I mean, our independence was formed on a basis of law, and we had this unique confluence of statesmen who were all lawyers who drafted this document, and it framed the basis of so many early struggles with Jefferson and Marshall and Lincoln and Tawney, and over again the Constitution has endured. People say we're in a constitutional crisis. I don't know what the hell they're talking about. We have we actually had a civil war, right? We actually had a war over the Constitution, right? We've had amendments, we've had Reconstruction, right? People today disagree on stuff, but hashtag squad goals, it's not that bad. All right, anything else? All right. What I'd like to do, did any of you go to the Langdell this past week? Did he go over the fall 2018 exam with you? Was it about the Lincoln and the impeachment?
No, sir, not in detail.
Which one did he go over with you?
He didn't go. He went over generally approaches, nothing specifically.
Okay, so here's what I'd like to do. This is my exam from December of 2018, so just about, I guess, 6 months ago, 7 months ago. And I want to walk you through it and give you just some thoughts of how I approach it. This will be the only class I go beyond the scheduled time, but I think you won't object to this one. I usually do a full class, but I think we can wrap it up tonight. And then Mom and Dad and I can get some dinner. The exam's 3 hours. There are 2 questions. That means roughly you should be spending 90 minutes per question. If you spend 2 hours on question number 1 and 1 hour on question number 2, you are in trouble because you did not allocate your time correctly. The word limit is 1,000 words per question, and that's 1,000 for question 1 and 1,000 for question 2. Do not give me 500 and 500. That's wrong. It's 1,000 and 1,000. Don't give me 2,100. I stop reading at word 1,000. There's a word count feature in the software. If you don't know how to use it, check with the registrar. They'll walk you through it. Do not do a character count. Every year, at least, not in this class, but every year at least one student gives me 1,000 characters. That's like 4 text messages, okay? And I know it's like, what the hell did this person, they're giving me the Kermit Frog emoji for an answer, right? But don't give me 1,000 characters. Thank you. Everything's open book. Bring whatever you want. It will not help you. In fact, if you find yourself flipping through the flipping through your notes, you're probably going to have time. The only thing you should be checking is like years of cases. If you've got a justice's name who's in a majority or dissent. But the crux of these questions are fact patterns that resemble a case you studied. I'll take a case and I'll twist it around. And you need to recognize, oh, he's talking about Romer. Oh, he's talking about Lawrence here. Oh, this is a Windsor. I see it, right? You have to see it. If you don't see it, you're not going to get the points. There are always two questions. The first question is going to be historical. So, for example, last semester, the setup was the year is 1867, right? In other words, you're before the ratification of the 14th Amendment. You're before Slaughterhouse. You're before Cruikshank. You're before Bradwell. The upshot here is I do not want you to cite stuff that happened afterwards. Actually pretend you are in the year 1867. You don't know what happened in a couple of years. You don't know. So limit yourself. When you get the question, the first part, I would read the prompt first. So this one says the year is 1867. Lincoln survives his assassination attempt. He's being impeached. Right? You're a law clerk for Chief Justice Chase, who presides over the trial. And he wants you to write a memo about the strengths and weaknesses of the articles of impeachment. There's always a fifth question, which I call the policy question, which is something to ask about a policy issue. But you need to bring cases in to discuss policy, right? Or legal principles, the Federalist or something that's law, right? You can't just say, I think this is a good idea because it's not fair. If that's what you give me, I'm not going to be happy. You need to, I say this lightly, but I don't care what you think. You can think whatever you want and like giving you points. I want to know, what does the law say about it? How should a court resolve this? No, I do care what you think, but not here. So I first recommend you read the prompt. Then I recommend you jump down to the questions, right? Right? And I would just skim. Where is it? Oh, this one was weird. I'll show you the other one is better. But usually, sorry. But I would then just read the question. So read the prompt first, and then read the 5 parts, right? And as you read through the 5 parts, I recommend you sort of outline and take notes on the side of things that jump to your mind. This is advice for all classes, but you don't want to waste time rereading the question too many times. Right? As you read through it, take notes, which starts getting your mental juices going. And think of it this way. If you have 90 minutes for the question, and you take 20 minutes to read the question, that means you have 1 hour and 10 minutes left over to write. Right? If you have 5 parts for 70 minutes, take maybe 10 to 12 minutes per question, which gives you some time at the end to check. So again, I would take 15, 20 minutes to read the question, and then 10 to 12 minutes to actually write each of the 5 parts. Give equal weight to each of the 5 questions worth the same number of points. Don't take 1 hour in the first part and then scribble number 5 at the end, because you'll lose a lot of points. Each question is graded on a scale of 1 to 10. There are 5 parts for a maximum of 50 points, and I have 2 parts. All right? What makes a 10? I usually don't give many 10s. I've never had 100 in any exam I've ever given, but people do get 10s here and there. To get a 10, you have to get a couple elements, right? First, you have to spot all the cases or authorities that are relevant, which is not always easy, right? I might be thinking of 5 cases, and then let's say you get 3 of them. That's probably good enough for a 9. But if you have 4 or 5 of them, I'm giving you 10. But it's not enough to cite the case. You have to actually explain how a given case is similar or different from the fact pattern, right? Again, I twist the facts around, say, this case is like Jones v. Smith, except there's a key distinction. Here's a distinction. And because of this distinction, here's why the case turns out the same or different. Right? That is what shows me you're able to think critically, right? That you can distinguish or say they're similar, right? Here's why the cases are lined up. And that's an important element to show me. If you can work some policy in, for example, discussions of like where federalism plays or why states have rights or how courts protect the rights of minorities, we have these various policy discussions, right? If you go through my old exams, you can probably figure out what I'm going to ask. I'm not that original, but go through these histories. Okay. So again, 90 minutes, 5 questions. Read the question 15, 20 minutes. Then take 10 to 12 minutes per question. Also, you have 1,000 words, 5 parts, roughly 200 words per part. Make them balanced, right? Don't put all of your words up front. Okay. So the first part, again, will be historical. The second part will be present. This was a question about the caravan of Central America, which seems like it's always in the news. But, I mean, you can just predict that the present question will be about Trump. I mean, I don't have to tell you, but whatever's going on now is it used to be Obama, now it's Trump. I mean, whatever's in the news. I don't expect you to know anything about the news. I'll give you all the information you need. Last year, I actually used several of the president's actual tweets. Some bad hombres. We're just in a circle. Just keep circling around. Socialists, right? This was based on the travel ban, which I didn't assign you this case, so I don't expect you to know it, but you can at least get a flavor for it. Yeah, one of the difficulties of reading past exams is I don't always assign the same cases, so there's no good way of fixing that. Some of the cases are the same, but the more recent ones, I cut stuff out, move on. Questions, things in your mind of how to anything with the exam. All the old exams are online. So there's really not many surprises. And if you at least try and take a couple of them, you'll be prepared for the exam. Let me actually finish on time. Okay, fewer questions than I anticipated. Questions? If you have any, please email me, and I'll set up a time to call you or whatever you want. But I'm confident that this is a wonderful class, and thank you all so much. Thank you.
Thank you.
Thank you. Please clap. Thank you. Standing ovation, no one's standing.